Hello viewers, myself Dr. K.S. Neharkar. I welcome you in my YouTube channel at lecture series on labor laws first. Friends, in this lecture we are going to discuss various authorities under Industrial Dispute Act 1947. So friends, we are going to discuss these authorities in two parts. So in this first part we are going to discuss some authorities, and the remaining authorities we will discuss in second part of this lecture. So firstly, we are going to discuss some industries in some authorities under first part. So friends, as you know, in last lecture we have discussed what is the basic object of Industrial Dispute Act. The Industrial Dispute Act is enacted to solve the industrial dispute quickly and smoothly. See, because industrial dispute must be settled quickly and smoothly. So the quick and smooth settlement of industrial dispute is necessary in the interest of industry, because it ensures constant production of products and services to satisfy the need and necessity of society and public at large. Therefore, the Industrial Dispute Act 1947 is enacted with certain objectives. These objectives are like to prevent industrial dispute, then to investigate industrial dispute and settle industrial dispute, then to establish and to maintain industrial peace and relations. So therefore the act provides different modes and modalities for the industrial dispute. Therefore the different modes are provided and different modalities are also provided. So the Industrial Dispute Act provides different authorities for the industrial dispute settlement. The authorities are like the different authorities which are established at industry and out industry, like the Works Committee, Conciliation Officer, Conciliation Board, then the Court of Enquiry, Labor Court, etc. All these authorities are there, and these authorities use different modes for the dispute settlement. So these modes are as like the conciliation. So conciliation is nothing but a role played by the authority to help both parties to solve the dispute through the negotiation, through the discussion and negotiation. Secondly, second mode that can be used by such authorities is adjudication, where the particular adjudication authority has to decide the dispute between the parties. Then third mode is arbitration. Arbitration means the parties themselves can decide who shall be the person who shall decide their matter. So arbitrators are appointed to solve their dispute. And lastly, the negotiation that can be directly done by the authorities. So there are different authorities that are provided by that act to settle the dispute, by which the dispute shall not go beyond the circumstances where the dispute cannot be solved. That is the reason why the Industrial Dispute Act is enacted. So it firstly regulates certain activities, certain acts by the employer and employees, by which the dispute may not arise, shall not arise, and even if any dispute arises, that will be solved quickly, amicably, by referring different authorities under the act. So now we are going to discuss which are those authorities under the act. The Industrial Dispute Act provides these authorities. So first authority which is provided by the Industrial Dispute Act is a Works Committee under section 3 of the act. See, actually second authority is Conciliation Officer, that is provided by section 4. Then next authority is Board of Conciliation, that is provided by section 5 of the act. Then next authority is Court of Enquiry, that is section 6 of the act. Then next authority is Labor Court, which is provided under section 7 of the act. Then next authority is Industrial Tribunal, which is provided by section 7A of the Act. And the last authority is National Tribunal, which is provided by section 7B of the Act. And now we are going to discuss all these authorities. Firstly, we are going to authorities under this lecture, and the remaining authorities will be discussed in next lecture. So friends, now we are going to discuss all these authorities one by one. So the first authority is Works Committee under section 3 of the Act. We must know what is the purpose for which this authority is established. See, basically this authority is established to provide or to develop a sense of partnership between employer and employees to run the industry. So as you know, in partnership there are two or more parties who take the decision of that partnership and for the betterment of that partnership. Similarly here, the industry is considered as a partnership firm for both the persons, though actually industry belongs to employer itself. But if such a kind of authorities are established, that feeling can be developed among the workers that industry is a partnership firm between employer and employee. So basically this is the thing. So when the decisions of industry are taken by both the parties togetherly, so that can be the feeling of partnership. So therefore the works committee is established under section 3. So works committee is nothing but it is a body which aims to promote goodwill and measures for production of common interest of industry. See, industry is the basic concern where the both parties have interest. They have the common interest, and their common interest is the development of industry, which will result into a development of employer as well as development of employees, because the interest of employer is to get the profit. Similarly, the interest of worker is to get maximum benefits out of that industry, including proper wages, different benefits, etc. So all this can be protected only ensuring peaceful running of industry and ensuring the betterment of that industry. So this section is applicable to all those industries where 100 or more workers are employed at least for the month. And once an industry is covered by this section, then it remains it remains to be regulated by this section. Then the works committee shall be composed. There is composition. That committee shall be composed of representatives of employers and employees. It shall consist of members are the representatives of employer and employees, and these members shall be equal from both sides. Equal from both sides. The number of representatives of employees and number of representatives of employers shall be equal in a number. The representatives of workers shall be chosen from the workmen's. Then what are the powers and duties of works committee? See friends, actually as I have already told you, the basic object of this committee is to protect good and to protect common interest of both the parties. Therefore it is responsibility of that work committee is to promote measures for securing and preserving amity and good relationship between employer and employee, because this is basic requirement for running successful industry. Then another power or duty of this works committee is to achieve above object by encouraging parties to protect common interest. So whatever the good things that should be done by both parties, and that should be done through the works committee. Then if there is any chance of any dispute, so that dispute should be solved by works committee by mutual agreement, or that should be solved through mutual discussion and negotiation between the parties. So the function of works committee is to ascertain the dispute and arrive at acceptable solution to both. So this is the works committee which works for the betterment of industry, and this is the best form of internal government in industry to regulate the industry through or with the cooperation of both parties. Then now we are going to discuss what is second authority under the act, and this second authority is provided by section 4 of the act, and this authority is Conciliation Officer. Friends, Conciliation Officer is appointed by central government by notification in official gazette. The Conciliation Officer shall be appointed by central government, and that shall be appointed by notification in official gazette. The government shall decide what shall be the qualification of that person who can be appointed as an officer, what shall be his jurisdiction where he has to work, what shall be his salary, remuneration, etc. Basically, the purpose of appointment of Conciliation Officer is to mediate and promote settlement of industrial dispute. See, conciliation is necessary when there is total breakdown of communication between the parties. When there is a proper communication, when there is establishment of proper communication, the dispute can be solved only through the discussion and only through the direct negotiation between. But when there is no communication, communication is breaked. In such circumstances, it requires third person to establish the communication between the parties and to require them to discuss the disputed matter and to take the decision on it. And that is the main role of Conciliation Officer under section 4, that to mediate and to promote settlement of industrial dispute by the parties themselves. So now we have to see what are the powers and duties of Conciliation Officer. Say the Conciliation Officer enjoy the following powers as like number 1, to enter into any industrial premises for the inquiry of industrial dispute. So to enter into any industrial premises. So whenever any matter is referred to Conciliation Officer for the inquiry or to mediate the dispute, he can enter into any premises, but it has to be entered within reasonable time. Then he can call any record in industry which is necessary for the inquiry. That record may be in the custody of the employer, or that may be in the custody of any officer to that effect, but that record can be called him for the necessary inquiry. Then to inspect any document for the inquiry, and industry includes many documents like the registers, accounts, whatever the different things that to be maintained under the industries, etc. So all these documents can be inspected by the Conciliation Officer. Then he has the same power that can be exercised by civil courts under Civil Procedure Act, Civil Procedure Code 1908. So it can be termed as, or he can exercise such powers regarding following activities. Like he can exercise the powers of civil court to enforce attendance, examination of any witness, examination of any document, inspection of any documents, etc. And he will be deemed as a public servant as defined by Indian Penal Code. So this a special kind of protection is provided to a Conciliation Officer, by which there should not be any kind of use of force against such person. Now we have to see what are the duties of Conciliation Officer. See, the Conciliation Officer has to perform certain duties also. Like the first duty of Conciliation Officer is the purpose for which he is appointed, and that is to hold conciliation proceedings. Then second is to investigate into the dispute and all the matters that are referred to him, and to try to settle the dispute by helping the parties. Then if the settlement is arrived, if he properly negotiates between the parties, he properly conciliates the parties, and then party arrives at a settlement. So if any dispute is settlement of that dispute is arrived, then to send such report to appropriate government with the signature of both parties on settlement agreement. So but this is in case when the settlement is arrived. But if the settlement is not arrived, then again it is the responsibility of Conciliation Officer to send such report to appropriate government, and that report should be sent along with necessary information on what the steps he has taken for the settlement of such dispute, and such report must be sent within 40 days from the conclusion of conciliation proceeding. So when such report is sent to appropriate government, then appropriate government can take the decision whether such dispute needs next steps, that it shall be, whether it shall be referred to any adjudication authorities for the adjudication. So friends, this is the second authority under the Industrial Dispute Act, where the conciliation officer is not going to give the decision on that dispute, but the role of conciliation officer is nothing but to help both parties to discuss the disputed matters, to identify the disputed matter, and to take the decision which will be acceptable to both the parties. So he is just going to help the both parties to solve the dispute amicably and quickly. Then friends, the next authority under this act is the Board of Conciliation, section 5 of the act. Friends, this basically the Board of Conciliation is constituted, appointed to bring two parties to dispute to sit together and to discuss their differences and to find out the solution. Similarly, what the purpose of Board of Conciliation is specific than the general appointment of conciliation officer under section 3. So the Board of Conciliation is constituted, or the matter is referred to Board of Conciliation for specific purposes only, specific disputes only. So regarding that, who constitutes the Board of Conciliation? The appropriate government by notification in official gazette shall constitute the Board of Conciliation, and that will be constituted for the specific matters or the matters of broad importance. Then what shall be the composition of Board of Conciliation? Actually, the Board of Conciliation consists of chairman and two or more members. So there can be odd numbers always. See, there can be a chairman and two or more members. The chairman will be appointed by the central government, and the chairman must be appointed, and who shall be independent person, and other members shall be appointed equally from employer and employees. So this will be the constitution of composition of members of Board of Conciliation. The government shall decide what shall be the qualification, jurisdiction, salary as it thinks. So now we have to see what are the duties of Board of Conciliation. Actually, the Board of Conciliation has to perform following duties. These duties are to endure to bring out the settlement of dispute, because basic object of this act is to solve the dispute by referring such authorities under the act, and where such dispute is referred to Board of Conciliation, it is responsibility of board to take all efforts for the settlement of dispute. Then if the dispute settlement is arrived, then such report should be sent to appropriate government with the signature of parties. Similar power is like the conciliation officer. Even if no dispute is no dispute settlement is arrived, in such circumstances also, it is the responsibility of conciliation officer to send such report to appropriate government, along with the information that what the steps he has taken for the settlement of dispute. So that should be done, and such report should be sent by the Board of Conciliation within 60 days from the conciliation proceedings. So within 60 days from the conciliation proceeding, he has to send such report. Then we have to see what are the powers of board. So the board enjoys certain powers which is necessary for the settlement of dispute. So these powers are, say, actually this is the higher forum for the dispute settlement, industrial dispute settlement, and it is constituted only for specific purpose, as I have already told you. So every member of board shall have the same powers as the conciliation officer. See, every member including chairman and other members, so they shall have the same powers as like the conciliation officer regarding the investigation and settlement of dispute. Then the board shall have to enforce attendance and to examine any persons, etc. As the civil court exercise that power, the the board of conciliation can exercise power of civil court under civil procedure code for the examination of witnesses, evidences, or to enforce attendance of witnesses, etc., which is necessary for the investigation and settlement of industrial dispute. And lastly, it has to act as a judicial body. So friends, these are first three important authorities under industrial dispute act. This is the first part. In next part we are going to discuss remaining authorities like the court of inquiry, labor court, industrial tribunal, national tribunal, etc. So friends, we will so join me in next lecture. So if you like this video, please like this and don't forget to subscribe this channel. Friends, thank you.